Good morning, all. Today we see about new kind of drafting, that is trademark drafting. Okay, so trademark பொறுத்த வரைக்கும் பார்த்தீங்கன்னா we all know we have the Trademark Act as well as trademark rules. In your UG you have covered the Trademark Act, but you may not come across the trademark rules. As I said earlier, when I deal with the CAT Central Tribunal, if you go with the any filing and all, okay, you have to see the relevant rules. For filing of a trademark, you need to verify the rules also, where in the rules they had given prescribed several forms. Okay, for a trademark filing you have two options. One is physical filing, another one is e-filing. For e-filing you must mandatorily have a digital signature. So digital signature, in case of a class 3, there are a different kind of digital signature. You need a class 3 kind of a digital signature. Okay, but then who can file? Either party themselves they can file, or an attorney. An attorney means a trademark attorney or an advocate. Okay, if you are an advocate, you need not be passing the trademark agent exam, or if you are not an advocate, you need to clear the trademark agent exam, then only you will be treated as a trademark agent. For an advocate, he need not be a trademark agent, because for a qualification to be a trademark agent, an advocate is enough. Okay, so if you're an advocate, you need not to write the examination, and you not register also. So but the register, you have to register only the website twice alone, but there is no separate register to be done before the trademark register. If you come to the filing, so it, as I said earlier, it can be filed by the either party themselves or the power of attorney. The power of attorney means even for the trademark agent or even for the advocate, there must be a power of attorney authorizing the agent to file the application on their behalf. Okay, so this is the essential requirement for a filing by agent. If it is done by the individual itself or by the company itself, there is no need to have this power of attorney, but they can give the authorization letter in favor of a person whom they are authorizing. Because if a company must act through some of the person for which they have to give authorization, there they need not to give any power of attorney, because the person who was authorized is acting on behalf of the company. There is no separate power of attorney is not necessary if the company itself filing the application and trademark application, or if the individual himself filing the trademark application. As I said earlier, we have had two methods of filing. One is physical filing, another one is e-filing. In order to facilitate the e-filing, the trademark registry has slashed the 10% of fees in case of e-filing. That is, preferable mode is e-filing. If you are going with the e-filing, you can pay only 4,500 rupees per class of trademark you are seeking for. In case of physical filing, you have to pay 5,000 rupees. That is, there is a 500 rupees difference. I said this fees is for one class of registration. If it is go for a two class of registration, that is, I will tell you about the class a little bit later. Okay, if we are going for a two class registration, so you have to pay 10,000 rupees in case of physical. In case of e-filing, you need to pay the 9,000 rupees. Likewise, the amount of you have to pay for the trademark registration varies based on the physical or e-filing, along with the number of classification. We come to the classification. In trademark register, we have the 45 classes. Okay, it's a classification done by all over, that is WIPO. It's also called as a NIC classification. Okay, so in which the group of services in one category. Suppose, say for example, in this example we are going to see the trademark registration, where you see label mark. This trademark is registered for class 29. You see, there is a class 29 for which there is class of goods of service. It is for class 29. So in class 29, there are many number of things are there. There is vegetables, food materials, whatever it may be. So these are classified under this category. Okay, so there are 45 classes are there, where all the substances are fit into the such 45 classes. Okay, I will go with another example. This is the trademark class website, where you can find out the classes. That is, if you don't know the class, you put enter the search term. Okay, then you leave the nice class as a blank, and then you have to select the which database you need to select. Here I selected the our Indian government database. Okay, so we can choose and we have to enter. Here I use the example vegetable. So vegetable, you see vegetable preserves, it comes under 929. If it's a vegetable wax, it comes under 4. If it's a vegetable chips, it comes under 29. If it's a vegetable spreads, it comes under 29. Vegetable crisps comes under 29. Okay, so it's the nature of the thing you have to classify the thing. You see vegetable smoothies. If your intention of the product is to be vegetable smoothies, the classification must be 32. Similarly, in case of vegetable pastes, if you are making vegetable paste, in our illustration we are having the garlic paste. Okay, so here these things comes under this category, class number 29. Okay, so there are many pages are there. If you go with the things, it will go all the things. That means you see salted vegetables, it comes under 29. Fermented vegetables comes under 29. If it's a raw vegetables, it goes under 31. Unprocessed vegetables, it goes 31. So it has the classification. If it's a tinned vegetables, it comes under 29. So based on the thing, if it's a cooked vegetables, it also comes under 39. Pickled vegetables, 29. So the classification defines what's the nature of the product for which you are intending to go for a trademark. That thing you have to analyze. So first we have to find out the classification which we are applying. Suppose say for example our client intend to register under class 29. So class 29 register பண்ண நினைக்கிறாருனாக்க, then for one class, as I said earlier, 4,500 rupees in case of e-filing. If they are going for two class, that is they want to register the trademark under class number 29 and 31. That is 39 refers to fresh vegetable or fresh vegetables. 31, you see, this is the thing. Okay, so then we can go for a two classification, 31 and 29, for which he has to pay the registration charges 10,000 for each class, 5,000 for two class. It is 10,000 in case of physical. In case of e-filing, 9,000 is enough. There is a 10% reduction in case of e-filing. So before you deciding to register the trademark, you have to find out which class you are going to register the trademark. Okay, then once you finalize the class, okay, then you have to search for is there any previous mark registered under this name, or is there any pending mark registered under this name. Okay, then you have to make a trademark search. After you find out there is no trademark, this is deceptively similar or similar trademark is there, then you can go for a application. So you have to use the form A. Okay, as per the recent amendment, you have to use the form A. In previous amendment, we have the form 1. Now it is amended. Now they given the alphabetic letter, so we have to fill the form A. If you are having digital signature, you can make the application through online e-filing. Okay, that is mandatory. There should be digital signature. In case of agent must have a digital signature, or in case of a person who is filing is the owner of the trademark, then they can have their own digital signature. So digital signature is mandatory in case of e-filing. Okay, so here this is the format which is filed under the e-filing. It is automatically generated. Even the receipt, everything is automatically generated. Okay, here you see the nature of application, trademark application. Application filed by others. Others means that the company itself. It can be of either agent or attorney. Okay, in this classification, here it is other, because the company itself is filing in this case. So you see they pay the fees for 9,000. Applicant number, there could be of many applicants, 1, 2, 3. Okay, here there is only one applicant, then the name, address, country, jurisdiction. So jurisdiction means for the purpose which trademark registries comes under the. Now online filing we can sit from Chennai, you can file any client from Delhi. Okay, if a jurisdiction and the client we can apply to the Delhi in, but you can file from Chennai. Chennai file online it's material where you are filing. It's the jurisdiction is based on the where the intended trademark is going to operate. That is the important thing. Though the registered trademark in Delhi, it is operating all over the India, but for the purpose of jurisdiction with respect to opposition, hearings and everything, we have to specify the jurisdiction based on the petitioners, that is applicant place of business. Okay, then we have the address for service, then mobile, email address and everything. So nature of the applicant, here the nature of applicant is body corporate. In case other thing, we have the advocate or a agent, other thing we can state. Here the latest status of the legal status of the company. Okay, in case of any agent is there, you have to mention the what's an agent. But as I said earlier, this is the application filed by the company itself. There is no details with respect to applicant agent. Okay, then we'll come to the mark detail. So category of mark, you know, there is a different category of trademark you can done. Word mark. Okay, so a device, whatever thing maybe. So here is there, they comes under the classification of device means something like a label. So update, you see, this is the intended trademark which they want to register. But you see, here is the word homemade, HOMMADE, which is a previously registered trademark. Similarly, Dauber is a previously registered trademark. Okay, so the other things were already registered, but they now want to protect this device as the label mark. As you see, there is an image description, they use as a label mark. Okay, so they have to mention if the mark is other than the language, you have to mention what's the language. Here the language is mentioned as English. Okay, as I said earlier, the class of goods of service, it's a class 29. Statement for use of mark. Okay, இது பொறுத்தவரைக்கும் is very very important. In the column வந்து ஒரு advocate பொறுத்தவரைக்கும் we have to think very deeply, because you all know there could be simultaneous applications. Okay, I will show another set of application where both the party filing for a same name, but different designs இருக்கலாம், but same நேமுக்கு ரெண்டு பார்ட்டி அப்ளை பண்ணுறாங்க. அப்படி வரும் பட்சத்தில் that could be serious problem. Okay, so this column is very very important. Statement as to use of mark. Sometimes we may having many clients where they are not aware about the trademark registration, but they will be using those marks for years and years. They don't know. You know, recent Tamil Nadu, even the Talapakatti biryani. Okay, without getting registered, they are using for years and years. Okay, there are many industries, many companies which are using their marks without any trademark registration. Okay, the thing is, if they are using for a very long period, we have to say from which period they are using the mark. This is very very essential. இதில் வந்து நம்ம எவ்வளோக்குள்ள பேக் டேட் நமக்கு ப்ரூஃப் இருக்கோ அந்த ப்ரூஃப் நம்ம என்ன பண்ணி we have to adduce all the proof from which date that particular trademark is in usage. Sometimes newly you are going to produce naka, then you have to intended, that is proposed trademark to be used. Like you can say proposed வரும் பட்சத்தில் there could be chances of opposition more. If it is a previous one, ரொம்ப earlier இருக்குது அப்படின்னாக்கா, then you can mention from what date that particular product has been used. That is, the mark is used by the applicant or its predecessor in title since so and so date. They mention the date in respect of the goods and service mentioned in the application. So mention the as class 29 and the class இருக்கிறதுக்கு வந்து they are using this mark. They using this mark continuously. Then verification. As I said earlier, this is the company filed the application. Here they authorized someone called Usha Kurana. They are the manager of the legal manager of the Dauber. So this is digitally signed. As I said earlier, digitally signed. Okay, so then this is the authorization letter. You see, authorization letter as I said earlier. So this is the company authorizing that Usha Kurana, legal manager, for all those things. So this is necessary for in case of a company. In case of a individual, they must give a power of attorney. Okay, this is authorization letter. You see, it must be stamped according to your rates. Here it is stamped for 50 rupees. You see, e-stamp is filed for 50 rupees. In case of power of attorney, if it is executed in Chennai, the power of attorney must be in 100 rupees. So it varies to the jurisdiction of the court. Suppose if this power of attorney filed in Chennai, it must be with 100 rupees of non-dual stamp or e-stamp. In case of other cities, there are in Delhi, I think they are asking for power of attorney for 50 rupees. Okay, so it varies on the jurisdiction. So all application must be contain this thing. Then this is the affidavit where they are sworn. Here, as I said earlier, it is already associated with some other trademark. That is homemade and Dauber is all already previously using trademark. So for which they are filing this affidavit. That is Article 4. As per the Rule 4, they are filing the affidavit. That is usage of the mark. Okay, they are describing what are the who is Dauber. Okay, then they are coming to the homemade. One of the most popular brand of the applicant is homemade, that was adopted by the applicant in 1996. The product of the applicant under the brand name homemade, including various lists. They are making affidavit. Okay, now they are declaring the homemade is registered under so and so trademark. That is in class 30. In class 30, this homemade name is already registered. பிகாஸ் இது ஆல்ரெடி ரிஜிஸ்டர்ட் ஆயிருக்கு. இதே நேம் மறுபடியும் இந்த மார்க்கில் வரும் பட்சத்தில் த ரிஜிஸ்ட்ரார் மே அப்போஸ், examiner may oppose giving the report already இருந்திருக்கு. So once we are filing this kind of affidavit, so we are linking this trademark application to the previously granted trademark application, because the same owner is applying for this thing. Okay, so that can be granted. If the different owner, then the registry cannot grant such trademark, because they are going to extend this product to a different sector. Okay, they use the registered the word homemade. In homemade, now you are asking, they are adding the one more part. You see here in the trademark design, Dabur homemade. Now they added the word green chili pickle. That is, this is the logo. You can take the label. Okay, so Dabur homemade is the actual thing. Now they are trademarking the whole label as their mark. As the affidavit is speaking about the whole story of the trademark registration. Okay, then they are giving the what are the other trademark related to homemade. Okay, so they are saying that what is the application date. So when it is granted, they mention that it valid up to. If it is pending, they are mentioning it is pending. Okay, so this is the application number or registration number. Okay, they are the homemade in variants in class number 29 and 30. It has been registered. So these are the many thing. You see there is a class in which it is applied for. Then from the date of application and what's the date of registration, if it is registered, what's the time period for registration valid up to. So that's a detail given. Okay, then they are using about the homemade, for the usage of that homemade, how much sale has been under the brand name, how much sale they has been completed. Okay, so this will make the how the reputation, how the goodwill has been earned by the mark. Okay, suppose if someone or some other one also claiming homemade, if they are claiming, they are also using the same name and they are simultaneous user. Okay, you can take this because they are have proving the sales records with respect to particular mark. Okay, so that the registry can able to assign mark to this person, even the opposition is made by the other person who is having simultaneous user. Their opposition may be defeated due to the usage. Okay, now they mentioned that the applicant has developed and adopted a new label which is unique and distinctive design in respect of food product like pickles and paste. The subject mark is an addition and an extension of prior existing mark of Dabur homemade. As I said earlier, it's an addition of a existing mark. So it can be granted only to the previous owner who is having such mark. This cannot be obtained by any other applicant. Then they are claiming that on account of long and continuous use, extensive advertising campaigns, enormous sale and excellent quality control, the applicant had acquired a good valuable goodwill and reputation regarding the goods sold under the trademark so and so amongst customers, the trade and public at large. So public at large as well as the tradesman, that is a stockist, retailers, wholesalers, everyone having the good name with the Dabur homemade, they are having the goodwill. So this is evident from the statement of sales derived from the books of accounts maintained. So that's why they are substanting the point why it has been registered, why they are having the how they establish the goodwill. So they had the affidavit. So then verification. Then this is the certificate of registration mark which is given to the homemade earlier. Actually they are substantiating that the homemade is registered in their name. So this is they are supplied to substantiate that the homemade is already previously registered. Similarly, they are extended the period of registration. So they also enclose the renewal of registration, because unless it is renewed, unless the trademark previously registered trademark is in force, they cannot be granted to the same thing. Okay, so this is the thing. So they have now provided the sales record. So they know this is the attachment which they provided, which prove that is the sales record. So they provided many invoice where they are using the what's the homemade product has been sold, how much it has been sold, what is the quantity it has been sold. So this is the model invoice where they get furnished. So by seeing all those things, the registry is making the examination. After seeing the application, they provide the examination report. This is the examination report where the registry stated that they accepted the mark. Then after that they publish the thing. So this is the mark which has been published in the journal, because you all know before a mark has been registered, it must be published before the journal for opposition. Okay, if there is any opposition, then opposition has to be dealt separately. If there is no opposition, then directly straight away they can grant the registration certificate. This is the registration certificate which is granted to the said label. You see, for the trademark as annexed, they mentioned that in the annexure they includes the what's the mark which is trademarked. Okay, so this is the trademark certification in respect to device mark, that is label mark. Next we will see about a trademark which is having opposition. Here pathina there is no opposition at all. It's a very simple case. It's clearly registered. நமக்கு வர கேஸ் பார்த்தீங்கன்னா நார்மலாக இப்படி இருக்குன்னு நம்ம சொல்ல முடியாது. Unless we have the very unique name, if there no one is having opposition இல்ல பட்சத்தில் it easily can pass through. But in many cases we can get opposition even from the examiner. நம்ம ஒரு நேம் போடுறோம்னா அந்த பர்டிகுலர் கிளாஸில் examiner may having give the report, this name already previous existing இருக்கு, அது descriptive similar இருக்குன்னு சொல்லிட்டு they may give a report. So we must substantiate we are a concurrent user. Okay, suppose say for example, if a person in Delhi they are using a one word for a spa. Similarly in Tamil Nadu, one person using the same word in spa. Okay, a person in Delhi who applied for a trademark registration, which the person in Tamil Nadu may not know that's a registration process. He's a simultaneous user. He's using for a very long period. Even before the person using it டெல்லியில் யூஸ் பண்ணுறதை விட தமிழ்நாடுக்கு ரொம்ப ப்ரையர் யூஸ் கூட இருக்கலாம் அந்த நேம். பட் த பர்சன் இன் டெல்லி who applied for a trademark registration, he may obtain the trademark registration. Then the person who obtained trademark registration in Delhi can injunct the person working in Tamil Nadu who is using the same name in Tamil Nadu which is prior to use. Okay, then in such case, if the person in Tamil Nadu, if he go for application of a trademark, then they have to establish it's a concurrent and simultaneous user. Okay, this person is not intent to steal the reputation of the persons in Delhi, because here the limited usage where the area பற்றின ஸ்பாவை பொறுத்தவரை பார்த்தீங்கன்னா லோக்கல் இன்ஃபர்மேட்டர் தான் வருவாங்க. there is nothing to do with the name of the Delhi person. Even we can establish that even prior to the filing of the trademark by the Delhi, அவங்களோட claim சொல்கிறாங்க from the period which they are using சொல்லும்போது அதுக்கு முன்னாடி நமக்கு ப்ரூவ் பண்ணுற மாதிரி சப்போஸ் ஏதாவது பில் அட்வர்டைஸ்மெண்ட்ஸ் வாட் எவர் எவிடன்ஸ் we are having அந்த நேமில் அந்த ட்ரேட்மார்க்கில் அந்த மெயின் கம்பெனி நேமில் நம்ம வேறு என்னென்னலாம் பண்ணியிருக்கோம், எப்போ பீரியட் பண்ணியிருக்கோம், அட்வர்டைஸ்மெண்ட்ஸ், சேல்ஸ் ஆர் இன்வாய்ஸ் வாட் எவர் இட் மேபி என்ன இருக்கோ எல்லாமே நம்ம if you prove as evidence, then that will be taken into account. Okay, then we may awarded with the trademark with a limited usage within Tamil Nadu. Even though there is a mark which is registered in the same name, but we have the restricted usage. If you see the Trademark Act, we have the provision. Okay, if you read the trademark completely, this kind of a simultaneous user provisions are there. Let us see the opposition in the next video.